I want to start out by telling you that I am not Brett Steele. My name is Richard A. Bourne. I'm with the Crime Commission in New York. Brett, who runs this network, actually couldn't make it this morning. To be honest, she had a chance to get her second vaccine shot, and we all know how hard those are to schedule. She tried to reschedule it. She couldn't reschedule it. I just insisted that she go ahead and get it. So she'll be trying to join us a little bit later in the program. So I'm going to do my best to convey to you what she asked me to convey, and then get this session going, the bulk of which will be done by our wonderful pro bono lawyers from Carlton Fields. So Brett did ask me to convey a few things, so if you'll pardon me, I'm just going to read through the things she asked me to describe. For those of you who are new to us, thank you for joining us. This is an emerging prevention practitioners network in the targeted targeted violence, terrorism, and hate space. We are building our presence, and you'll be hearing more about us and probably getting an invitation to join us in upcoming months. This workshop kicks off a mini series on legal liabilities. Today, we will be talking about civil liabilities, and then we will have a subsequent session on criminal liabilities, and then a third one on balancing legal and privacy requirements in information sharing, which I know is a complex topic. The workshop this morning will be presented by a law firm called Carlton Fields, and with three of their lawyers, and I'm going to talk about them in a second. There are a couple of things I do want to mention, actually, that Brett asked me to mention. I don't want to let her down, so excuse me. So after Carlton Fields presents, we will then go into an open dialogue Q&A. Some of you have already submitted questions, and I will probably start with those questions. I'll read through some of them. I'll probably combine a number of them just to keep us moving along. And then depending on how much activity we have going back and forth, we'll either go to an open mic situation, or Addie will take questions in the chat room and I'll just read them out. We do encourage you to ask as many questions as you want. And please, this is a complex area even for lawyers. I'm a lawyer. This is a complex area even for lawyers. So don't be the least hesitant to ask any question at all, even if you think it's something we covered and you didn't get, or even if you think it's a frankly silly question. Please ask it. This is the time to do that. Again, these are complex questions, but they are questions that involve everybody, that everybody needs to be aware of, who operates in this space. So before I go to introducing our lawyer friends, I do want to thank, on behalf of Brett, and I actually know how much they're doing, the Institute for Strategic Dialogue, who was just a critical partner in this effort. One of their esteemed staff members, Charlotte, has prepared some fantastic materials for this and other dialogues that we've done. Actually, I don't know how she does it. She's not a lawyer, but she seems to really be able to capture the essence of these various seminars. We also want to thank the ADL, who have been a fantastic partner, and of course, our good friends at the Department of Homeland Security Office of Targeted Violence and Terrorism Prevention. They have been a very close colleague and support network for us at the Crime Commission since our earliest days of getting involved in this space, and they continue to be just an incredible resource. They are so incredibly knowledgeable and helpful. It's just a real pleasure to work with them. So now let me introduce the run of show, and then I'll introduce the lawyers. So unlike our previous seminars, we're only going to have a limited number of presenters, and the presenters will go for probably a little bit more than an hour. We'll see how they pace themselves. So we've carved out a spec more than an hour. We will then go into the Q&A. And as I said before, I'll start by going through some of the questions that have been submitted, and then we'll either go to open mic or chat room. 80 will keep us true to the clock. So let me introduce Carlton Fields. So at the Crime Commission, we're in New York. At the Crime Commission, we are incredibly lucky to work with a pretty robust number of law firms that offer pro bono services to the work that we do. And it's everything from analyzing constitutional issues that we get involved with, to submitting briefs to the United States Supreme Court, to looking at litigation that we may want to enter because of public safety concerns, and then the very, very complex issues around this topic, around civil liability. Carlton Fields, which is a national firm, they have well over 300 lawyers, has exemplified just the best in what you want to have in a pro bono firm. They have been there every step of the way for us. They have come forward and offered to do things far beyond what I was even willing to ask for. I'm willing to ask for a lot. And they've done it with thoroughness and professionalness. I actually felt like I was a paying client. The quality of the work is just so high. And that is characteristic of the pro bono work that they do. My contact within the firm was originally Natalie Naparala, who is a New York-based lawyer who has been involved with us for quite a while. She not only does pro bono work with us, but we also do job placement for high-risk individuals, and she does a lot of our mock interviewing, training people for those real job interviews. She's just an incredible human being and a fantastic lawyer. The pro bono team is led by Sylvia Walbolt, who is a very well-known litigator, mostly at the appellate level, and has an extensive record of doing pro bono work. In fact, has been recognized a number of times by various bar associations and other civic organizations for her work. And then there's Ben Stearns and Stephanie Chow, who Sylvia is going to introduce. So I'm going to turn this over to them, but with a very, very hearty thanks to Carlton Fields for all the work that you put into this. I know it's been an enormous amount of work, and we really, really appreciate it. Sylvia?
Thanks, Richard. We're happy to be here. You've introduced Natalie, who is the one who recruited us as a team to help her on this project. The team was Ben Stearns, who is from our Tallahassee, Florida office. The bios, I think, are in the materials that have been handed out. He's basically a specialist in regulatory matters, legislative matters, and the like. Stephanie Chow, who's from our Los Angeles office, is basically a business litigator. Not with us today is Kurt Taylor, who couldn't be with us today, but was an active participant and upward delegated to me his section that he had worked on, which will be the last section we will address. All of these people devoted considerable time to this project. I would estimate that they spent 3 times what I assured them they would have to spend when I asked them to first join the effort. But they've been good sports, have done a very comprehensive memo from which this presentation is largely drawn. But having said that, it's obvious, I hope, to everyone that they could not possibly research every potential jurisdiction where litigation might arise. And so we've narrowed it at this stage to mostly the Federal Safety Act and New York law. We have not addressed in any detail, although I think Stephanie will briefly allude to it, the interaction of some of these issues with HIPAA, which will be, as Richard indicated, a part of the third workshop. Although the research has been restricted, we think it will provide you with and hope it will provide you with a good overview of the potential issues. But everybody should understand, as Richard's previously alluded to, that these are complex issues. They often depend on the particular facts of the case. The laws differ from jurisdiction to jurisdiction, and there may be some states with oddball statutes that we aren't familiar with that could come into play. And with respect to terrorism, and particularly domestic terrorism by our own citizens, this is obviously a very fast-moving, evolving area of the law. And so when it comes to answering questions from you guys. You may hear a lot of, that's a good question, I don't know, maybe, depends. The questions are going to be hard for us to answer, and then often it may just be our best estimation of what we think the answer is likely to be. But I stress as an underlying factor that the work that the CCC does and that practitioners and providers assist it in obviously is serving a great public need and interest, and that fact is likely to inform courts in all jurisdictions in a positive way when they're faced with claims of liability arising out of mental health services under this program. And finally, nothing we say today should be taken as legal advice. It's purely for educational purposes to help you have a sense of the legal framework and legal issues when you talk with, as you should, your own lawyers with respect to the particular circumstances of your own work, including any contracts you may have. As I was preparing my notes for this disclaimer, I was reminded of a trial I was in as a very young lawyer a million years ago. It was an antitrust trial in federal court down in Miami, Florida. And the plaintiff's lawyer got up at the beginning of jury selection and said, good morning, ladies and gentlemen, I'm so-and-so, I represent the plaintiffs, and I talk funny because I'm from Vermont. And it got a smile from all the potential jurors and everybody on our side. And in a little bit, my lawyer stood up and he said, good morning, ladies and gentlemen. I represent the defendants in this case, and I talk funny because I'm a lawyer. And everybody in the courtroom broke out laughing, just as you guys are, but there's some unfortunate truth to that. So hopefully we won't talk too much like lawyers today. And as Richard said, there's no such thing as a stupid question or a silly question. We hope you'll feel free to ask, particularly if we're not clear on something. So with that, Ben is going to start with the Federal Safety Act, which is a very, very interesting act that some of us had never heard of before we began this work, but is integral to the inquiries and questions you may have. So Ben, take over.
Thank you both Sylvia and Richard for those very kind introductions. You're both far too kind. And I just want to take a second to say thank you for the opportunity to help all of you in whatever small way we can with the important work that you do. It's a great opportunity for us to contribute to what you all are really doing, which is the really important work. Addie, I just want to ask real quick, are the participants able to see the presentation?
Not at the moment, no. Do you want me to share it?
Yes, if you wouldn't mind, that'd be great.
Okay. 1 moment. Okay.
Or alternatively, I could do it, I suppose. Okay.
There we go.
Perfect. Thank you very much. Okay, so today I will be talking to you all about the Safety Act. The Safety Act is a relatively little known act that was enacted as part of the Homeland Security Act of 2002. The Safety Act consists of about 9 pages out of that massive legislation, and it really, as such a small part of that legislation, received relatively little attention. But it probably should have gotten more notice because the potential protections that it offers are significant where it is found to apply. So the Safety Act, which safety stands for support Anti-Terrorism by Fostering Effective Technologies Act of 2002. The purpose of the act was to ensure that the threat of liability does not deter potential manufacturers or sellers of anti-terrorism technologies from developing, deploying, and commercializing technologies that could save lives. There was a fear that developers of technologies or services, and I should be clear, and we'll discuss this further as we go on, that technologies is used as a blanket term to refer not only to products, but also to services that could potentially be useful in either deterring, preventing, recovering from, or lessening the damage caused by an act of terrorism. So the Safety Act furthers this purpose by providing limits on liability that may accrue to a seller of what is known as a qualified anti-terrorism technology under the Act. I'm going to refer to that as we discuss the Act as a COT for brevity and ease. A COT is a product, device, or service designed or developed for the purpose of preventing, detecting, identifying, or deterring acts of terrorism, or limiting the harm of such acts, and which are designated as a COT by the Secretary. Now, Section 441 of the Act, which is the first section of the Act, authorizes the Secretary of the Department of Homeland Security to designate anti-terrorism technologies that qualify for protection under the Act, a COT. The Act provides, and this is important to note, a non-exhaustive list of criteria that are to be considered by the Secretary in determining whether to designate a particular technology as a COT under the Act. Those criteria are provided on the PowerPoint, and they include prior United States government use or demonstrated substantial utility and effectiveness, availability of the technology for immediate deployment, existence of an extraordinarily large or unquantifiable potential third-party liability, substantial likelihood that the COT will not be deployed without protection from the liability afforded by the Act, the magnitude of the risk exposure to the public if the COT is not in fact deployed, evaluation of scientific studies that assess the capability of the COT, and if the COT would be used in fact to prevent, deter, or respond to terrorist acts. Now, the implementing regulations make clear that the Secretary has a very significant amount of discretion in determining whether or not to designate a particular technology as a COT under the Act. The regulations specify explicitly that the Secretary need not actually consider each and every one of these criteria, and in fact state that if a potential COT does not satisfy one of the criteria at all, that is not, in fact, a disqualifying factor in determining whether or not to designate the COT as a COT under the Act. The Secretary can put varying weights on certain criteria. He can consider criteria that are not even enumerated in the Act. Again, the Act bestows a very significant amount of discretion upon the Secretary, which he may also delegate to his undersecretary, the Undersecretary for Science and Technology in the Department of Homeland Security. Now, there are three types of COTs that are provided under the Act, and those are the Developmental Testing and Evaluation Designated COT, a Designated COT, and a Certified COT. These three levels provide varying levels of protection and duration of that protection. The Developmental Testing and Evaluation criteria or designation is not actually provided in the statutory text. It was created by the Department of Homeland Security through the implementing regulations, because the department recognized that there may be some technologies that are in need of further study that would not receive that further study and probably would not be developed any further were they not to receive some level of liability protection. So that this designation is really designed to encourage further the continued development of new COTS to combat and deter, prevent terrorism. Both the DT and E designation and the designated COT levels of designation under the Act provide the seller of the COT with the same liability protections. And those liability protections consist of a limit of liability to a certain level designated by the Secretary upon his approval, his or her approval of the COT. They also afford the seller the right to exclusive jurisdiction of claims brought in court against that seller arising from the deployment of the COT in federal court. So where a plaintiff brings a claim against a seller of a COT, they may only do so in federal court. They may not bring such claims in state court. The certified level of COT provides a further level of liability protection for sellers of COTs in that it provides a rebuttable presumption of application of the government contractor defense. This is a very important level of liability protection in that if the government contractor defense applies, which is an affirmative defense that can be asserted in litigation by a defendant, it provides complete immunity from liability for that seller of that COT. So a very, very significant amount of protection from liability. And in fact, the only way to rebut the presumption that the government contractor defense applies is for the plaintiff to demonstrate that in applying for certification under the Act, the seller of the COT either engaged in willful misconduct or fraudulent misrepresentation of the technology to the department. Absent such a showing, the government contractor defense applies to completely immunize the seller of that COT from liability. The structure, section 442 of the Act establishes some of the things that we just discussed. It establishes an exclusive federal cause of action for any claim resulting from an act of terrorism. That's a significant point that we'll come back to later in our discussion of the Act, when a COT has been deployed. Relevant claims must relate to injuries that are proximately caused by a seller. Again, a very significant point in actual application of the Act. Proximate causation requires that the injury would not have occurred but for the deployment of the COT. So the COT must be a significant part of the chain of causation of the plaintiff's injuries. A seller under the Act is any person or entity that sells or otherwise provides a COT to federal or non-federal customers. And non-federal customers is later defined in the Act to include both state and local authorities and commercial enterprises. So the COT may be sold to non-governmental entities that deploy the COT, and the Act's liability protections still apply. Claims may only be brought against the seller of the COT and may not be brought against buyers or other downstream customers of those buyers. Again, a very significant differentiator for a potential technology that achieves designation or certification under the Act. The seller can represent that the Act will immunize those downstream customers from liability under the Act, because the Act only provides that actions may only be brought against the original seller of the COT. They may not be brought against its customers or downstream customers. The Act also prohibits the award of punitive damages or prejudgment interest against the seller of a COT. It limits the award of non-economic damages, so damages for things such as pain, suffering, or mental anguish, solely to plaintiffs that have suffered an actual physical harm as a result of the act of terrorism, and prohibits the award of joint and several liability against sellers, such that a seller may only be held liable for the amount of non-economic damages that are directly proportional to that seller's percentage of responsibility, such that if there was a certain amount of non-economic damages that could be attributed to another party other than the seller, but that other party is, the plaintiff is unable to get their judgment, they're unable to satisfy their judgment from that other plaintiff, the seller may not be held liable for that amount. They're protected from what is called joint and several liability. The Act also provides that collateral source recoveries, so recoveries from things such as insurance or other defendants and other actions by plaintiffs, are set off from recoveries against the seller. So if a award is made through litigation against the seller of a COT, and an award or an insurance recovery is also made by the plaintiff for those same injuries, that award that was awarded against the seller will be reduced by that amount that the plaintiff recovered from insurance, for example. And then we discussed the rebuttable presumption that is provided to sellers of certified COTs. Now, we touched on this briefly. The Act, under all three levels of designation, provides a limit on the liability that the seller may be subject to. And that liability is established by the Secretary through the application process. And under the Act, the seller of the COT is required to obtain liability insurance commensurate with that amount of liability that is established. The Secretary of the Department of Homeland Security determines the type and amount of liability insurance that the seller must obtain. And this amount of liability insurance is intended to be sufficient to satisfy third-party claims against that seller that arise from a deployment of a particular COT and an act of terrorism causing injuries in the context of the deployment of that COT. The amount of liability insurance that may be required may not be more than the maximum amount that is reasonably available on the world market at prices and terms that will not unreasonably distort the sales price of the COT. The way that this is implemented under the Act, the application process, which is significant but manageable, requires the potential seller of a COT to submit information to the Secretary regarding the amount and type of liability insurance that the seller currently holds and would provide coverage for any potential losses associated with the use of this COT, as well as the terms and conditions of those liability policies that the seller currently holds. In some instances, it's possible that a seller will not have been able to obtain liability insurance for the COT or losses related to deployment of the COT. And in those particular instances, the application process requires the seller to submit information regarding their efforts to obtain the insurance and why they were unable to do so, which may simply be that they could not find an insurer that was willing to write insurance for that, or if they did find an insurer that was willing to write such insurance, that it was prohibitively expensive. And the secretary will take all of that information into consideration when determining the amount of liability insurance that is required to be obtained by the seller of the COT, and also hence setting the cap on the liability that that seller may be subject to. Another significant point to keep in mind in relation to liability insurance requirements is that the department stated in the implementing regulations that even where a seller's liability insurance lapses, the protections of the act do not immediately lapse as well. The amount of liability that was established by the secretary in granting the designation or certification remains the cap on the liability that the seller will be subject to, but the seller is simply subject to that amount as opposed to the insurer before their insurance policy lapsed. Now, moving on to a quick discussion of Section 444 definitions, provides a significant definition of the term act of terrorism. And the act defines an act of terrorism as any act that the secretary determines meets the following requirements. The act is unlawful, causes harm to a person, property, or entity in the United States or a United States air carrier or US flagged or based waterborne vessel anywhere in the world, and the act uses or attempts to use instrumentalities, weapons, or other methods designed or intended to cause mass destruction, injury, or other loss to citizens or institutions of the United States. The act and the implementing regulations specify that the designation of an act of terrorism under the act is a non-delegable duty of the secretary. Only the secretary of the Department of Homeland Security can designate a particular act as an act of terrorism. And until an act is designated as an act of terrorism for purposes of the Safety Act by the secretary, none of the liability protections apply to any losses that emanate from that act. This is, again, a significant requirement that we'll discuss in a little bit more detail as we get into a discussion of the MGM litigation. Now, the MGM litigation is the only litigation to date that has involved a deployment of a certified or designated or any level of qualified anti-terrorism technology under the act. The MGM litigation ensued from the attack on the Route 91 Harvest Country Music Festival in Las Vegas in 2018. A shooter opened fire upon the festival from the 32nd floor of the Mandalay Bay Hotel, which was located across the street from the festival grounds. 60 individuals were killed as a result of this attack. More than 500 were wounded, and many others traumatized as a result of the attack. Mandalay Bay, the hotel from which the shooter conducted his attack, was owned by MGM. The festival grounds where the music festival was being carried on across the street from the Mandalay Bay was also owned by MGM. And MGM had hired a Contemporary Services Corporation to provide security services for the festival. And at the festival, the CSC, Contemporary Services Corporation, deployed a certified COT, which were its security procedures to protect the festival. The certified COT that the CSC deployed consisted of things such as evacuation routes, facilitating the movement of people through the festival grounds, screening of people entering onto the festival grounds, seek shelter methods for when an attack was ongoing. So they really pertained directly to the actual venue of the music festival. They did not relate, however, to things that were going on at the MGM Mandalay Bay Hotel across the street. However, an argument could be made, and I think would have been made had the litigation continued, which we'll discuss, that although the certified COT deployed by the CSC could not have prevented the attack as the attack took place from the 32nd floor of a hotel across the street, it certainly could have been useful in reducing the harm that that attack caused, such that it would trigger the protections of the Act. However, as we'll discuss, such a final determination was never made. The Route 91 Harvest Festival was the first event at which a COT was deployed, and the ensuing litigation is the only time that the Safety Act's protections have been asserted in litigation. This may be a result to some extent of the fact that the Safety Act, as we discussed starting out, is relatively little known. And up until recently, there were not a whole lot of filings for protections under the Act. I think within the first 10 years after the Act was enacted, only about 900 technologies achieved designation or certification under the Act. Since then, the pace of applications for protection under the Act has picked up, as well as the pace of actual designations and certifications by the Department of such acts, such that now I believe there are a couple of thousand COTs that have been designated or certified, but I mean, it's still a relatively small number, which probably has some effect upon the fact that the Safety Act's protections have never been asserted in litigation before. But coming back to the MGM litigation, plaintiffs across the country, as this was a big music festival that was attended by residents of all 50 states, it appears, began either filing actions in state and federal courts against MGM or submitting pre-lawsuit preservation notices to MGM, indicating a possibility that litigation would be forthcoming, although not actually getting to the level of filing such a complaint. A group of plaintiffs did file a lawsuit against MGM in Nevada State Court, and MGM removed that action to federal court, arguing that the CSC's deployment of a COT at the festival triggered the Safety Act's exclusive federal jurisdiction. As a way to combat the proliferation of lawsuits that were being filed or were potentially going to be filed against MGM, MGM also filed preemptive federal declaratory judgment actions against plaintiffs in 8 federal courts around the country, seeking a declaration that the Safety Act applied. MGM argued that as a purchaser of a certified COT, it was entitled to the presumption of the government contractor defense, immunizing it from any liability for any losses suffered from the act of terrorism. against the music festival where the COT was deployed. The plaintiffs raised a number of arguments against the applicability of the Safety Act. The plaintiffs argued that the CSC's deployment of the COT had no effect on the attack and was not a quote unquote proximate cause of their injuries as required under the act to trigger the act's liability protections. Plaintiffs also argued that MGM's alleged negligent acts that proximately caused the plaintiff's injuries had no relation to the deployment of the COT. They noted that the CSC was not a defendant to the litigation, and plaintiffs raised no claims related to the deployment of the COT. MGM was not a quote unquote seller of the COT and therefore did not have standing, according to the plaintiffs, to seek removal under the act. And significantly, the Secretary of DHS had not declared that the act was a quote act of terrorism under the act. MGM countered this argument by arguing that the Secretary had in fact referred to the attack on the music festival as an act of terrorism, but in congressional testimony and other department statements. But the plaintiffs argued that this was insufficient, that the act required an official declaration of the act as an act of terrorism by the Secretary in order to trigger the act's liability protections. The plaintiffs also argued in particular context of the declaratory judgment actions filed by MGM that there was no actual case or controversy between the MGM and the now declaratory judgment defendants, as the declaratory judgment defendants had not actually filed a lawsuit against MGM, and MGM merely speculated that they would do so, which is insufficient under federal case law to establish a case or controversy. They also noted that the act is an affirmative defense, making it inappropriate for providing the basis for a declaratory judgment action. The plaintiffs also noted, or argued at least, that the reliance upon the act of MGM did not further the act's purposes because MGM was not a developer or seller of the COT. And so any liability borne by MGM would not deter a seller from continuing to develop or sell COTs. Unfortunately, none of these arguments were ever finally determined. The litigation is useful in that it highlighted potential issues and arguments that could be made in the context of a claim for protection under the act, but without a judgment, a ruling on any of those arguments, it's impossible for us to say how those arguments would have been addressed by the court. MGM argued against the plaintiff's arguments that the Secretary had made public statements, as just discussed, designating or describing the act as an act of terrorism, that the CSC security procedures had been certified as a COT, and that the act's protections extend to a seller's customers, not just to the sellers. But the litigation settled prior to any ruling, and so, well, we've got questions. We don't have any answers regarding these arguments. Now, a little bit of additional commentary related to both the MGM litigation and just the structure of the act itself and the implementing regulations. One commentator criticized MGM's reliance upon the act as an attempt to flip the standard litigation structure in order to control lawsuits against it. And in making this comment, the commentator was specifically speaking about the declaratory judgments, the preemptive declaratory judgment actions filed by MGM against potential plaintiffs as a flipping of the standard litigation structure. Two other commentators on a different subject questioned whether the DHS's extension through the implementing regulations of the Act's protections to downstream users of a COT would be upheld by courts. And they also questioned whether this protection of all downstream users, such that a potential plaintiff may only file a lawsuit against the seller, could have unintended negative consequences for the seller, as it would concentrate all of the litigation against solely that seller. And finally, these commentators noted a provision in the implementing regulations related to modifications of a certified or designated COT. The implementing regulations provide that routine or minor alterations or modifications of a COT do not have any effect on the protections afforded to the seller under the Act. However, significant modifications require notification to the DHS. However, the Act doesn't specify exactly what would qualify as a significant modification. Further, the implementing regulations provide that any modifications made to a COT by a downstream user of that COT also do not affect whether or not the liability protections of the Act apply. But if a downstream user makes a significant modification to the Act, which is not required to be noticed to the department, even if a significant modification made by the actual seller would be required to be noticed to the department, can that downstream user nevertheless still rely upon the liability protections of the Act? Unfortunately, these are just questions that we have regarding the Act, and we can't provide any answers under the current case law. And I think that's about it for my initial discussion of the Safety Act, and I'll turn it over to Stephanie.